sits there and taps his hands, and you're just sitting there, and he sits there and rocks back and forth in the chair, like, big old another murderer or whatever he is, convicted. Up to this point of a case, not in handcuffs, not in shackles, one or the other, or both, and in orange.
Everybody, excited utterance here. My name's Hella, and it is a Bryan Kohberger stream, an Idaho 4 stream. Hashtag. Wow, it's been a little while since I've run the Flight of the Valkyries music by Wagner, and I love the dramatic music. I just love the old dramatic music by Wagner. Dramatic music. I'm back. Dramatic music. Dun, 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 dun. You know who else loves dramatic music? Dateline. Yeah, Dateline loves dramatic music. And the defense not too happy about that. In fact, I don't think Judge is too happy about that. No one's very happy about that, except everybody who thinks Bryan Kohberger is guilty and a narcissist and an incel. Which is weird, because there's never really been any evidence or anything in the court documents to make out like this was sexually motivated, right? Yet Dateline did a really good job of trying to make out that this was sexually motivated, this crime, right? But now we have a motion to continue by the defense, and if you don't know what a motion to continue is, that's just like court terms for asking for more time. And guess what, state of Idaho? You've done a really, really stupid thing. Someone there has done a really stupid thing by leaking information to somebody who's leaked information to somebody over at Dateline, so they could make their dramatic piece that they put out, which painted the narrative of Bryan Kohberger being guilty, and included a lot of information from his phone, witness testimony. There was CCTV that none of us have seen yet from 1112 King Road. We've only seen frames of it, of the supposed suspect vehicle 1. So we're talking about privileged information that was under seal, and there is a non-dissemination order, so a gag order, which has been in place for 2 years. Right? So somebody from the state, and it wasn't the defense, come on, there's people out there who are like, oh, maybe the defense dropped it. No, that's ridiculous. It was someone from the state, and the judge knows it. Right? Someone from the state has leaked this information to the media. That's not the first time that things have been leaked to the media, right? We're all just kidding ourselves if we think that this is the first time stuff has been leaked to the media. But this is blatant, and it's very close to trial, and it's the first time it's really happened in front of Judge Hippler, and he doesn't like it. Right? Now, why is this important when it comes to the motion to continue? Well, let's just say the defense has tried a lot of different things when it comes to trying to get the death penalty off the table prior to trial. I think personally that this is another attempt to get the death penalty off the table. And there's a lot of other things in this motion to continue which talk about the overwhelming amount of discovery and how the defense is not ready for trial because of the overwhelming amount of discovery. And we'll talk about that in a moment. However, so far, the judge has said in many ways, too bad, so sad. But hidden down in page 36 of this document that we're going to have a look at, there is very clear reference to this leak and the Dateline special, and also another upcoming leak, which has already been announced, of a book by James Patterson, who is a crime writer. That's supposed to be coming out 2 weeks prior to trial, right? So, Ann Taylor has mentioned all of the other reasons she thinks there should be a continuance, but the one that is pertinent and has come up that's out of the ordinary, that has not been mentioned yet, and we know it's close to the judge's heart because he is angry about this leak, it's that, right? So we're going to talk about that in a minute. First, I want to say hi to everybody here. So, hey, to die for. Hello, Diane. Yeah, so my question that I had put out there in the title and the thumbnail for this is it really Bryan who wants this continuance? Is it him that wants more time? Hell no. Do you think he wants to be hanging about in jail for another year? God, no, right? And of course, like, people are going to be out there saying that stuff. Oh, he just wants more time. He doesn't want to face the death penalty, right? Yeah, right. No, he'll be doing what his lawyers are advising. And he has done all along. No more steak leaks. It's gross. Hey, Kat, how are you? Good to see you, love. Curry, how are you, Curry? Good to see you, mate. Okay, Mavka. Hella will be on time today, unlike Kohberger's trial. Well, death penalty trials take a long time. They do. And this is something I have spoken about before. People are impatient for this trial to happen. They think that this trial is like every other trial and it should happen within a year or two. But it's a death penalty trial. It's a quadruple homicide with a death penalty. And death penalties take much longer because there is this mitigation phase that needs to be prepared for. And there's a heightened amount of due process that needs to be taken. Without it, there will be appellate issues. Absolutely. And I mean, there will be anyway, right? But Ann Taylor talks about it in detail in this motion to continue. But just death is different. That wording is used a lot in these cases. And when I had Steve Gosney on here last year, he spoke about it because he has a book called Death Penalty Designs, and he speaks about this concept of death is different. Once the death penalty is there, everything gets blown out. You just can't be impatient for it because the defendant has a right to his life. Simple. Just for that, I should distract Helen. No. Hey, Johnny Osprey. Johnny on the spot. How's it going? Scott is here. That's awesome, Scott. I'm glad you said that. Hey, half Irish. Latent Tasmanian. I love that. Ivermectin. Hey, matey. Hey, you, mate. Bree is here. Hey, Bree. Hey, PPM. Yeah, yes, you did make a live. Good to see ya. Snibbles. Hey, Snibbles, thank you for the donation, mate. And thank you for the memberships last week, too. Seraph thanks you. Seraph this morning snotted Suni and the dog, Sybil. So he's getting his strength back, right? Snotted means whacked, right? So yeah. And he's meowing and he came up and he even like, hey, human, do the thing you do. All the regular stuff. So happy. He's really coming around. Thank you so much. And yeah, we're fundraising, guys, for Sarah's medical bills because that was very expensive. He's not out of the woods yet. He's still sniffling and stuff, but thank you. Hey, Christine, how are you, love? DB says Dr. Gary B said it were sexual. Who's Gary B? Well, we got to believe him, don't we? Whoever he is, he's a doctor, right? Like Dr. John and Dr. G. All these doctors, they're always right, right? Yeah. Yeah, I'm a doctor of fake lawyering. I heard on Murder Sheet that he wants a delay because they were afraid of the dollhouse. See, every now and again you come out with a good one, Mavka. See, this is why you're not banned for life. This is why we keep you. Half Irish says, I'll admit I usually like Dateline, but that episode was garbage. Yeah, I can't say I like Dateline. I think it's always garbage. But hey. Them getting a bunch of people to talk about Kohberger was ridiculous. I just can't. And also, Half Irish, did you see the Richard Allen episode of Dateline? And I know that they tried to get certain people to talk, and it seemed like it was going to be like an expose on how there was a wrongful conviction, right? But it wasn't, of course. Yeah. So they kind of sweet talk people into thinking that the narrative is going to be different to what it is. Yeah. Did the Dateline guy say the defense wouldn't talk to? Yeah. Yeah. Absolutely. So I think it was at the end, they said, oh, we contacted the defense and they refused to speak to us. Of course, because there's a freaking gag order, you idiots. So that means you contacted the state and they did talk to you, right? It couldn't have been them. No, but see, the judge has to do the right thing and give the same order to both the state and the defense. And we'll talk about what that order is in a minute. Maybe it was the court clerk. Maybe. Brian's a hunk and he's fine. Hey, Eamon. Maybe it was Joe's judge. Hey, maybe. The James Patterson thing. I don't even know about this James Patterson, but how many books are there goddamn gonna be? Right? Hey, Young, how's it going? Squeaky wheel. He's either going to be hanging out in jail or hanging out in prison. Time has stopped for him either way. Yeah, it has. It's really, really sad. It really is. This man, he's 30, gonna be 31 soon, and yeah, he was about to just embark on his life, and yeah, time's just stopped. You're right. I can't wait for Hella to read this comment in 10 minutes. Shut up. Hey, David, how are you? David, thank you for the 199 super chat. This is from Young. It's all she can afford. Thank you, Young and David. Hello, maybe Tonya. Good morning or good evening, Hella. Mods in chat. Yeah, it's morning for me. And hello. What was the best piece of advice you received when you were going through divorce? That's a bit personal. Are you going through divorce? I hope not, because your wife's lovely. Anyway, Stoles. Yay, what happened to who? What happened to him? Who's him? Hey, Deep. People are so mad at the defense for taking 2 years, like the judge isn't the one approving the motions. Oh, we'll talk about that in a minute. The defense is not the one who has taken 2 years. This part really makes me mad, right? People who think the defense are the ones who've taken 2 years are not following, right? There have been 6 motions to compel and 22, count them, 22 supplemental requests for discovery, right? Each one of them you can go through and they list out all the things that they're asking for, right? So many are outstanding. And here's the thing, he was meant to go to trial in October of 2023. We were all set to go. Like, David, you remember you were ready to stream in October of 2023. It was supposed to be the same week that Sarah Boone went to trial, right? Because obviously hers got continued, right? So everyone was all worried because, Sarah Boone and Bryan Kohberger are going to trial in the same week. How are we going to handle it? Yeah. And I think Taylor Business was also supposed to be around the same time. Imagine if he'd gone to trial then. How much stuff has been handed over by the state since then? So what's going on? If he had gone to trial then and all the things that the state has handed over since then never got handed over, what? The defense was just never going to find out about it? He was just going to go to trial without all of that stuff ever passing between the parties, right? So the defense has had to pull all of that information out of the state since then, right? So here we are, mid-2025, 18 months later, things are still being handed over, and people are blaming the defense for this? What bullshit? What absolute bullshit. My wife and I tried to watch that Dateline episode. We turned it off after 2 minutes because she cannot stand the friend of a friend of a friend who was crying. Yeah, right. And I didn't like the body language. Oh, that body language. Yeah, look, I mean, I'd have to get a body language interpreter to come and interpret it for me because otherwise I don't know what it means. Yeah. James Patterson can stop writing. He has enough money. I don't even know who this person is, but I don't read crime books. Dali, shut up. 10 minutes later. Hey, CH, how are you? Of course it is all because of the defense, DP. Didn't you get that memo? I mean, didn't you? Really? Yeah. Hey, been there, done that. I haven't seen you for a while. How are you, mate? Good to see you. I hope Anne makes a snide remark about the prosecutor's dollhouse during trial. Okay, so then they're not going to call it dollhouse anymore. So Bill Thompson came along and went, that was kind of my fault. I shouldn't be calling it the dollhouse. That's kind of inappropriate considering what happened there. So we'll call it a model. Is that okay with everybody? We'll call it a model. Okay, we'll call it a model. Fine. Yeah. Yeah, it's a dollhouse. Hey, young Black economist, how are you? It's a model, but it's not to scale. So it's not a scale model. It's just a model, right? Well, wouldn't it make sense that he's a mainly fiction true crime writer, just like somebody else we know, right? Someone else we know. Okay, so let's get into this. In context, the Dateline episode came out, I think it was around 12th of May, something like that, and happened to be just before a hearing. So the hearing was on the 15th of May. Now, I did a stream about the Dateline episode, and I pretended that I decided that he was guilty. because I was so creeped out by the selfies, right? The selfies were so incriminating. Him in the hoodie, he just looked so creepy. I couldn't help it. He's guilty and also a narcissist, right? And also Holly, that chick that he met at the pool party, I was so convinced by her. And the text message, oh my God, the text message, right? The text message where he said, that hiking activity, could you please get back to me and let me know? That was so formal and therefore creepy. And he must be a murderer and a narcissist, right? So yeah, Holly clearly liked him because, yeah, she gave him her number. But then later, she was clearly freaked out because he must be a murderer, right? You're scaring me. Well, that's kind of what I do. Yeah. Anyway, so I did a stream on that, and I really didn't expect that the judge would say or do anything about the breach of the non-dissemination order. And I still am a bit iffy that he's for real about all this. I feel like this is a little bit of box ticking, but I will show you what he did at the hearing, right? So let's have a bit of a look. It was pretty brief, but he did do something. And I just go into here. Hang on a minute. Okay, here he is. And why is he standing up? Oh, no. I just go back a bit.
Indicated to you, I am going to be entering an order requiring retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel.
Here you go. Have your order.
And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena.
Ooh.
And the power to question witnesses under oath, as well as the power to grant immunity.
Actually, DB made a really good cut of this. Look at the look on Ashley's face. Ashley's like, don't look at the order. Don't look at the order. This is not about us. We have not done anything wrong. Deep, I'm going to send you a link. Hang on. Hang on, I'll press play again so you can watch.
So I will be looking for that from you. And that one just deals with the state. I will get you one that deals with your side to preserve records. All right. All right. Anything else? All right. Thank you. Why don't we come back in about an hour? All right.
How about you go and think about what you've done? See, they've gotten away with this for so long. They have a public mouthpiece, and sorry to say it, but it is the father of one of the victims, right? So the father of one of the victims has been giving out information that's under seal from the court, not from the court, from the state for a really long time. He goes on News Nation, he goes on Court TV, he talks to the press, and he gives out information that is absolutely not okay to be publicized and even make stuff up as well. That's just not true, right? And taints the public view, taints the narrative so that it looks like Bryan Kohberger is obviously guilty, but that he has some sort of connection with the victims, that he is further involved in some way. Earlier on, in when this first began, he told the media that Bryan Kohberger's phone connected to the house's Wi-Fi. That is absolutely false, right? 100% false. So things that were being spoken about, that were being investigated, they were passed to the victims' families who had some sort of level of discretion, but there's a gag order, right? Now, their attorney, Shannon Gray, talking about the Gonsalves family now, was brought before the court early on. So this would have been early 2023. This was back in Judge's court. Was brought before the court regarding releasing of information. And I don't believe that there was any official prosecutorial action taken, but there was a warning given, right? But you know, you've seen it. You've seen what's continued to happen. More and more and more things have come out from that source. I don't like to badmouth that source. Lots of people do, but it's been happening on and on and on. So, and there's also another source. There's this Howard Bloom who gets about saying that he knows information from the state. He doesn't say the state, but he says he's got inside information. Who knows whether he actually does or whether he's just making shit up. Steve G's Facebook group is gone. Yes, I just tried to get on there this morning and it's gone. Either it's gone or it's locked off to non-members because it was a paid page, right? There was a public side to it, and then there's the paid subscribers, right? I was never paying any money to get onto the Gonsalves family page or whatever it was. So I went onto it this morning to see if I could see their reaction to the motion to continue, and you can't get on there. So I don't know what's going on. Yeah, it's gone completely. Is it? I wonder if that's because of this. So the order that the judge just gave to the two parties, I'll show you what it looks like for the state. And I just need to stop that and bring in my Acrobat. Okay, so that's what this looks like. Get rid of your comment off the screen, right, Deebs? Hey, young black economist, despite state orders, some say they still think defense leak. They think defense leak in an attempt to get case dismissed. That's so stupid. It's just so stupid, isn't it? Yeah. Okay. So, right. So this is an order from the court based on sensitive information not previously publicly circulated that was reported during a recent Dateline TV program related to the case and the defendant, Bryan Kohberger. It appears likely that someone currently or formerly associated with law enforcement or the prosecution team violated the court's non-dissemination order. Ha! So he said it flat out. Right? He said it flat out that he thinks that it was the state. Huh. Suffer, state. Suffer. Such violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impede the ability to seat an impartial jury. Yes, and will likely substantially increase the cost to be borne by the taxpayers of Ladar County to prosecute this case by extending the time it will take to seat a jury and potentially requiring a lengthy period of juror sequestration. Accordingly, the court finds it is imperative to attempt to see that the source of such leak is identified and held to account. Ooh. And that doing so is the best deterrent to future violations. Accordingly, the courts find it appropriate to exercise its discretion by entering this order. It is hereby ordered that all persons who at any time, past or present, work directly or indirectly by employment, contract, consultation, or otherwise for or on behalf of any law enforcement or prosecution agency engaged in the investigation or prosecution of persons for the murders that are the subject of the instant case are hereby prohibited from deleting, discarding, overriding, or destroying, altering, or otherwise making unavailable any, whether electronic or immaterial form, records, files, documents, metadata, messages, emails, text message, direct or private messages, phone logs, or logs of communication, regardless of whether made or kept on a work-owned or personal account, device, or messaging app. Wow, this is pretty broad. That in any way relate to or document the fact or substance of communications with third persons, including representatives of the media or other persons or entities outside of law enforcement, which communications in any way relate to, refer to, or concern the investigation of Bryan Kohberger, the facts or allegations uncovered or reported to law enforcement concerning Bryan Kohberger, or the investigation into homicides that are the subject of the current or then potential criminal prosecution of Bryan Kohberger, collectively documents, or singularly a document. All such documents or materials or records that could potentially constitute a document, even if it is uncertain which such meet the criteria, shall be preserved and must be protected from deletion, alteration, or loss until further order of the court. Any feature of any device or account that is set to automatically delete, you've got to turn off automatic deletion, or override information that could be covered by this order must be immediately disabled. Peter's chat's gotten crazy. I bet they're all like, they just want more time because he's scared. Delaying it again. Poor families, they just need justice. Justice. Right? I bet that's what's going on. Guarantee that's what's going on. I bet, yeah, too much wine. Right? The wine would be flowing. And too bad, freaking so sad. Sorry, not sorry. This is Idaho versus nobody else but Bryan Kohberger. It's his name up there, and no one else is going to be standing in front of a firing squad except him. So, people who've waited too long for justice, yeah, cry me a river, right? You've been waiting too long for justice because they got the wrong guy. You can wait longer. In fact, if they've got the wrong guy, then you're going to be waiting 20, 30 years too long for justice. Right? So it's not Bryan Kohberger's responsibility to heal your wounds. It's just not. It's just not. It's not. This is not up to him. And he's the one who is being targeted. So, very sorry for your loss, but this is not the remedy. Hey, Bunny Murphy, how are you? Good to see you. They use firing squad in SC and miss target and batch. It's vicious, the DP, cruel and unusual punishment, my opinion. Yeah, I'm completely against the death penalty, and no one can change my mind on that one. So yeah. Okay, this bit is pretty full on. So it is further ordered that within, and he thought 14 days, and it's like he was so mad that he had to scratch it out. Like 14 days, no, 7 days, not 14, 7. "7 days. The state shall submit to the court in camera a list of all individuals within law enforcement and prosecuting agencies, past or present, who are known to have had access to any facts related to the investigation of defendant, including but not limited to surveillance videos of suspect vehicle 1, the AT&T records for defendant's cell phone and the content of defendant's cell phone and other electronic devices and social media accounts, including internet search history, photographs, and information associated with the defendant's Amazon account, or any information referenced in the above-mentioned Dateline episode regarding this case." I just love the way he's... I love the way he scratched it out. How funny. 7 days, don't answer the phone. What is this, The Ring? Yes, well, you heard the intro music, so yes, it is The Ring. The state is further required to provide a copy of this order to all such individuals and document that it has done so. Failure to comply with this order may be a basis for a finding of contempt of court. Yes, contempt of court, my lovelies. Contempt of court. And such other civil and criminal consequences as may be appropriate within 7 days. The state must also provide to the court a written plan designed to address and prevent further unauthorized disclosure of information related to this case and what it has done or proposes to do to identify any violations of the court's non-dissemination orders previously entered in this case and those responsible for such violations. So they got hand-delivered this order in that hearing. You saw it, right? So you saw the bailiff physically hand the order to both parties. And some people are making a big deal of the fact that it got delivered to both parties. He had to, right? And I'll show you. Actually, it's not easy right now for me to show you this, but on the docket, it actually reads order. What's this called? What's the name of this? Order for document and records hold. Order, document and records hold, and then order for document and records hold - defense, right? So it's like there's one, which is the one he meant to make, and then he's like another one that has like defense. I've got to make one for the defense. Hey, Mickey's headphones. 7 days usually is business court days. Yeah. Yeah, it would have been done. So I think it has been 7 days, hasn't it? 7 court days, unless there's been any public holidays. We might be around that time now. But okay, so here's the thing. They have this notice of hearing, right? Now, interestingly, and this really drives me crazy, that Renee Waters, the deputy clerk, is in Comic Sans. What the hell? Guys, this is an official document. Help me. Help me. Right, so dated 15th of May, I certify that on this date, I served a copy of the attached via email. So this hearing will be held via Zoom. The clerk will send out the invitation prior to the hearing date. So the date will be May 21. So has it already happened in your time? Yes. This is called Notice of Hearing, Discussion Regarding the Role of Victims, sealed. Right? Now, don't know whether this breach of the non-dissemination order was discussed at this. It could have been more to do with other items that are on the docket right now, including seating arrangements and also some points regarding people speaking to the media throughout the trial. And I believe that Steve Gonsalves has said that he was going to address the media every single day at the end of the court sessions. Now, the reason I bring him up again is because guess who is on this list at the end? If you don't recognize this name, Shannon Gray is the attorney for the Gonsalves family. There it is there. So every other lawyer name on here is an attorney of record for the case, right? So Bill Thompson, Jeff Nye, Josh Hurwitz, he's a new special prosecutor. Ashley Jennings, we know she's got no soul. Madison Allen is a special assistant attorney general. So there's all the state ones. And then we got Ann Taylor, Eliza Bicaballo, the new DNA specialist, who's also a lawyer for the defense. Jay Logston, public defender. And now here's Shannon Gray appearing. He's not an attorney of record for the case. He's an attorney for the Gonsalves family. Why is he being invited to this? Well, he's the only attorney being invited on behalf of anyone else outside of lawyers for the case, right? Is he being addressed on behalf of the Gonsalves family because of breaches of the non-dissemination order? We don't know, but it would make sense, wouldn't it? And yes, different font again. It's like it's been added at the end, but it is the same as Trent Tipple, who is the clerk of court. He is the Becky Hill, maybe, of this, but let's not taint him. Let's not taint him, yeah? Does Shannon have a master's? Yeah, I noticed that Shannon is spelled with one N. They removed Facebook hate group this morning. Is significant and for a reason. Oh, 100%. 100%. I don't think that's an accident that the Facebook group has been removed now. Because that Facebook group was full of sensitive information, right? So it's very possible that that's been removed due to a court order or because they're scared. Yeah. Okay, so let's get into the motion to continue. And I'm not going to go through the whole thing. It's a big document. There's certain parts of it I want to refer to. We may need to refer to some other things that have happened recently, though, to put them in context. So here it is here. Now, let's just be clear, and this is my take only, but oops. It's my take only, but I think that the defense team, and I'm not just going to refer to Ann Taylor here because I think that Eliza is in a way kind of running the show at the moment. And I'll talk about that a little bit more soon. But Eliza is very much underestimated in terms of her part that she plays in this team. So Eliza Mathos, she's second chair as far as this team is concerned. She is a huge part of what's going on, and especially in sort of the last 6 to 8 months. Ann Taylor has taken on another death penalty case, much to the sort of disapproval of Judge Hippler. And Ann Taylor isn't the best at delegating, but she works well with Eliza. All right. You would have seen Eliza do her oral arguments, and she's strong. She's very, very strong. She's also excellent with her documents as well. I hope to see her play a really big part at trial. But what's been happening that I've noticed, and that I've had some conversations with some people who have been following the case very closely, is that Anne appears to be falling short when it comes to this argument about the overwhelming amount of discovery, the potential Brady violations that relate to that, because of the fact that she's not been effectively delegating. She's been taking on other stuff that makes it look like she therefore is able to handle this quite well, really. And she's not arguing her points in a cohesive fashion. Judge Hippler requires far more detail than Judge did. Eliza has worked with Judge Hippler a lot more. So Ann Taylor is not from this area. Eliza is only an hour away and has worked with Judge Hippler before, and she has a better understanding of how Hippler works. And I feel that Ann Taylor was far more comfortable with Judge, whereas Eliza is better suited to Hippler's style. So we'll go into a little bit more of that soon, but let's just look at this. So comes now Bryan C. Kohberger, by and through his attorneys of record, and hereby respectfully submits the following motion to continue due to the substantial amount of trial investigation and preparation still outstanding, as well as recent and forthcoming publicity that is highly prejudicial to the defense. Any conviction and sentence resulting from a capital trial beginning in August 2025 will be unconstitutionally imposed and therefore vulnerable to reversal on direct or collateral review. In making this motion, Mr. Kohberger relies on his right to be free from cruel and unusual punishment, his right to due process, his right to a fair trial, his right to counsel, his right to present a defense, his right to confront witnesses, his right to a fair and reliable sentencing determination, and other rights safeguarded by the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, Article 1, Sections 6, 7, 8, and 13 of the Idaho State Constitution. Right, so here's all the, she sets out in the table of contents all the many reasons for the motions to continue. Now, she starts with the obligation of the court to uphold Mr. Kohberger's constitutional rights. Now, yeah, so she starts with this thing about the additional time to review discovery. Obviously, that's going to get a lot of people's backs up because she's said this quite a few times already, and Judge has already said that You've had ample time. You haven't established any violation by the state. The judge has pretty much argued for the state and said, too bad, so sad. They've given you everything you've asked for, I think, which I have problems with that, considering that there's been already a trial date set. And since then, a ton of stuff has been forthcoming. It's taken a lot of time to get to there. So if that's the case, then why, I repeat, why are we at this point now? And he would have gone to trial back in October of 2023. But I digress. Let's be clear. She's not going to get a continuance because of this. Right? So just go and have a look at this. She ain't getting a continuance. Right? Does anyone in chat disagree with me? Stop it, Max Bureau. Hey, online. I know there are not a ton of DP qualified defense attorneys in Idaho, but 2 at once seems bonkers. Yeah. The level, like the amount of volume just of this one is out of control though. Like, was it 57 terabytes or something? I don't know, old line. It just to me it seems like they can't possibly assign enough to keep up with the state. But yeah, so old line red. No, she's been told this first argument is a no-go by the judge. Exactly, right? So I feel that she has to put this down, but she knows full well that there's no way that this argument is going to fly, right? And show you why. Here's the most recent ruling regarding this. Yeah, death is different. But so this is the most recent ruling by the judge in regard to the motion to strike the death penalty and adopt other necessary procedures. She has done several motions regarding the voluminous amount of discovery, right? Sanctions, there was another motion to strike the death penalty that was citing the Vallow case. And so here's what the judge has to say about this. I've highlighted some sections. So defendant claims that the state has failed to satisfy its obligations under Brady and ICR 16 due to its method of discovery production. He contends that the state has turned over more than 68 terabytes of data in discovery, consisting of in excess of 13,000 photographs, 15,000 video clips from businesses, and 8,000 video clips from residences. It also includes more than 60 digital devices, digital data, and search warrant return data. Defendant also contends the state has not provided the discovery in a searchable format, has not provided detailed logs and indexes that would facilitate defense's review of the material, and not specifically identified any Brady evidence. Defendant argued he has been prejudiced by the state's data dump method of discovery and contends that sanctions are warranted in the form of striking the death penalty and excluding witnesses. He also asked that the court required the state to identify Brady material or hot documents within its discovery. While the state acknowledges there is a massive amount of data in this case, it contends the majority is completely irrelevant. See, I have an issue with that, but it's too bad, right? I think there are a few issues with the judge's argument here, or ruling, I suppose, but it doesn't matter. He's made his ruling, right? He said it. So let me just pop down here. So the state also notes that since this case began over 2 years ago, it has continuously turned over to the defendant all the information it received from the various investigating agencies in the same format as the information was received by the state. But that's 2 years, right? So, yeah, this is what I've been saying. It's been 2 years, and it's been continuously handing things over. But there was a trial date set in October of 2023, right? So why are you continuously having to hand things over for the last freaking 18 months? What if we went to trial back in October of 2023? What about all this stuff that's come along since then that they've had to just like pull out like teeth, right? That shouldn't have had to happen. So I just don't understand why it's okay that the defense has had to ask and ask and ask and ask and get little pieces handed over such a long period of time. And then, Judge, you go and cover for them, sweep for them and go, oh, that's okay. They've been handing things over for 2 years. It makes no sense to me. Oh, this was done at the defendant's request. Yes, they shouldn't have even had to keep requesting. Why? 22 supplemental requests for discovery? Is that really freaking necessary? Has anyone even heard of such a thing? If you put DP qualified on your Tinder profile, you get kicked off. If you put it on your Grindr, say goodbye to your inbox. That's discriminatory. I love you, Max. Yeah, DP. She's doing a lot of preserving ineffective assistance of counsel claim for him. 100%. Yeah, there's lots of that in this. Okay, so number 5. Where's number 5? To find where number 5 gone? Table 5. Ha, 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 ha. 4, 5. Oh, yeah. So all this, 68 terabytes of data, 13,000 photographs, 15,000 video clips, 8,000 video clips from residents. So that's 5 down here. So 5. Other than those identified in warrant applications, expert disclosures, motion practice, and in the exhibit list, the numerous surveillance videos show nothing of consequence. Well, that's great, isn't it? Isn't that awesome? Nice to know that. Awesome. So you're saying that it's not just a dump of data? So state points out that on September 4, 2024, now remember, that's nearly a year since the first trial date was set. Right? A year later, nearly. 11 months. State points out that on September 4, 2024, at approximately the same time as its discovery deadline, it provided defendant with a 320-page index identifying the location of requested discovery, a description of the evidence, and the date discovered. In addition, all of the evidence received from the FBI, which comprises the majority, was provided to the defendant with a searchable index. What the hell are they doing providing that 11 months after the first goddamn trial date? And Judge Hippler, why do you think that's okay? Oh, thank you for the $10 super chat. Editing my Grindr profile now. Thanks, Max Mirror. Yes. Max Mirror is full of great advice. I love you, John. Yeah, nothing of significance, really? Really? So, okay, so let's have a look at footnote 8, shall we? When defendant ran into a problem with some of the disclosed PDF documents with password protection, the state worked with the defendant to resolve the problem. Wasn't that nice? What is this? Like, are they paying you under the table, Judge? Like, are they providing you with, like, you know, a lady of the night? Or, you know, I don't want to assume that what your preferences are. Further, voluminous discovery alone is not a basis for finding concealment under Brady. This occurs typically in open file discovery, where the government effectively makes its entire file available to a criminal defendant. United States versus Safarina. This method of discovery, which defendant requested of the state in this case, carries the recognized benefit of increasing the efficiency and fairness of the criminal process. Okay, so it's only when the government uses the open file policy to hide exculpatory material or otherwise prevent a defendant's access to such material that a Brady violation will be found. For example, in United States versus Skilling, the Fifth Circuit observed that while the use of voluminous open file does not alone violate Brady, its misuse by the government can give rise to a Brady violation, stating, for instance, evidence that the government padded an open file with pointless or superfluous information to frustrate a defendant's review of the file might raise serious Brady issues. Creating a voluminous file that is unduly onerous to access might raise similar concerns, and it should go without saying that the government may not hide Brady material of which it is actually aware in a huge open file in the hope that the defendant will never find it. These scenarios would indicate that the government was acting in bad faith in performing its obligations under Brady. Dear me. While the state acknowledges that much of the discovery is completely irrelevant, including surveillance videos and data from the numerous phones, computers, and other devices, it did not produce it for the purposes of padding the file or otherwise attempting in bad faith to hide Brady information in its haystack of information. Really, Judge? Are you sure? Were you there? Rather, defendant asked for everything, and everything is what he received. Defendant cannot demand everything under the sun and then complain about the weight of the planets. Oh, he's a poet. This was interesting. Other than the cell phone, digital data, and video surveillance footage, defendant has not identified what information his counsel will be unable to review prior to trial and why that information is material. Well, don't you think that's kind of important, Judge? The cell phone, digital data, and video surveillance footage, don't you think that's kind of goddamn important, Judge? Bloody hell. Jesus Christ. Further, at oral argument, lead counsel indicated that her practice is to... Okay, now this is interesting. Now, this is where he's got something on Ann Taylor. She's messed up, right? And this is what I was talking about earlier regarding her... seemingly her inability to delegate effectively, and it's coming across to Judge Hippler, and he's calling her out for it. So, further at oral argument, lead counsel indicated that her practice is to personally review all discovery herself. rather than rely on associates and staff to review materials to cut through the less relevant information and point to what materials need review by lead counsel. Ouch. These actions are not indicative of an overburdened defense team. He's got her there. In fact, it's evident defendant has been able to capably navigate the discovery, given his more than robust motion practice, the scope and breadth of the experts retained, and the disclosures filed. So now he's saying that, wow, you write such good motions and they're so long and detailed that you're clearly doing fine. Yeah, Mickey, kind of not though, right? She shouldn't have said that. It's fine for her to want to look at everything, but it wasn't a good thing to say because he's got her on that, right? They continue to talk about the breadth of discovery and how it's beyond the capability of any humans, basically, right? And it is. So 68 terabytes it's just unfathomable. And then she goes and says, oh, but I want to review it all personally. How's that going to fly? Right? How are they ever supposed to get to trial if she wants to review everything personally? And I get it. I kind of want to see things personally too if I were her. She's doing her best. But as far as the judge is concerned, that's just her not being a good manager and not being able to manage her time well. So he's called her on it. Yeah. Online, yeah, I'm a control freak and don't trust my fellow attorneys to read. It's a terrible argument. Yeah, to read, it's a terrible argument. Yeah. Yeah, I mean, it's a catch-22, Miku. It really is, because, like, she clearly really believes that Bryan is innocent. She does. She wants to do everything she can. But how can she? It must suck to try and go to sleep at night thinking, what the hell am I going to do about this? Right? But there's just not enough hours in the day. Darling, she has to delegate for a DP case. It sucks, but she has to. And yeah, like, she's cut off her nose to spite her face. Like, she's done such a good job, and her team has done such a good job with the motions and making sure they cover their butt by putting in all of the responses and meeting all the deadlines. But then the judge goes and calls them out and goes, well, you say that you can't keep up. Look at how robust your defense is. Your robust motion practice. Look at it. And then you want me to give you more time because you say that you can't be prepared? Come on now. Yeah, you have to be able to delegate and you have to trust co-counsel. Going through discovery is not just reading, though. You have to read everything closely. Yeah. Research if it's correct, cross-check, verify. Yeah. Like, I'm with you. I'm with you. It's just, I think the judge's thought is that if one person were to do that, it would take 20 years. And his bosses aren't going to accept that it's going to take 20 years. Yeah. It's the judge who was demanding trial start soon. Bryan was forced to waive speedy. Yeah. So fuck you, stay. He gets the time he needs. Well, we'll see. We'll see. But here's the thing, though, Miku's headphones. Death is different. But here's the thing. He's already ruled on this. This is a ruling, right? So he's already ruled on this is striking the death penalty based on this. So this is him saying this, that too bad. you've already shown that you can handle this. Okay. So yeah, the court declines to impose organizational requirements on state. And we'll get to the end. Based on the foregoing, defendant's motion to strike the death penalty and adopt necessary procedures due to the state's disclosure, violation is denied. Shock. Right. So let's go back to the motion to continue. So like I said, the court has an obligation to uphold Mr. Kohberger's constitutional rights by vacating the trial date because defense counsel needs additional time to review discovery. No. He's already said he's not striking the death penalty, so there's no way he's going to give it a continuance. Right? No. He's already made this argument. He's already ruled on it. Yeah, it was pre-dateline. So that's why she comes in with this one, right? That's why she comes in with this one. So she goes, well, Judge, a continuance is necessary to remedy the prejudice of highly inflammatory publicity released just weeks before the current trial date, including the recent Dateline special and forthcoming book. He doesn't have to do anything. And he hasn't done a lot of things that we thought he had to do. No, he doesn't have to give extensions. Nope, not at all. No, we've seen plenty of cases where we've thought that just judges have to give continuances and they haven't. Okay, so this one's very interesting. But before we actually go to this section, I just wanted to touch on some of the other reasoning that she's put forth. She's saying that they need more time for the mitigation. So that is for his sentencing phase, assuming that he's found guilty. So note, again, this has a lot to do with death penalty, right? So just imagine, right? If death penalty weren't there, this problem wouldn't exist, right? So counsel's professional and ethical obligations in a capital case, right? So there's a whole section on this. Counsel's duty to provide effective assistance of counsel in accordance with prevailing professional norms. The minimum requirement counsel must meet in investigating for the merits phase of a capital case. Counsel must conduct an exhaustive, unparalleled life history investigation, analyze hundreds of documents and interviews, and compile all this information into a cohesive narrative for sentencing phase. What a constitutionally adequate investigation entails. A full investigation is likely to lead to discovery of numerous mitigating factors that would not be readily apparent from a cursory investigation. So they're saying that they ain't ready for mitigation, right? Now, if you remember, back when they first walked into Judge Hippler's court, and Taylor said, I have a little bit of a problem I need to bring up with you. We have an expert who has died. So that was in August last year. Now, that expert that died was their mitigation expert, one of their mitigation experts. Now, if you're not familiar with a sentencing phase in a death penalty case, they're long, they're intensive, and they talk all about the defendant's life, everything that led up to the potential, the crime, their childhood, their sort of traumas, their psychology. The expert gets to know the family, the background of the defendant in like intimate detail. So that person died, right? They had to get somebody else. Now, she had someone else ready to go, but they had to start from scratch, right? So this is why death penalty cases take much, much longer because of this mitigation phase. So there's also, besides the fact that this person died, there's also this expert disclosure deadline, right? Now, if you remember, also, Ann Taylor and Eliza, they put in a motion for sanctions for the state regarding their lack of disclosure regarding their expert witnesses. They said that they did not give anywhere near the amount of detail that they needed to give regarding their expert witnesses. They said they just basically gave CVs. That's pretty much it. Whereas that's not enough. They need to provide like a full list summary of what they're going to be speaking about so that they can brief their experts, right? And Judge Hippler pretty much swept for them and said, that's not unusual, but he tried a little bit, but it was pretty lame, right? So that's all necessary for the defense to get their sentencing phase ready, because that's them fighting for his life. And it's all within the realm of the Constitution. They must do everything they can as his attorneys to fight for his right to live, basically. They must do this. Otherwise, his death penalty will get overturned quite quickly, right? We'll talk about also how likely it is for his death penalty to be overturned. So see all this stuff. There's a reason why all this stuff is here. And it's because, in my opinion, this is not about a motion to continue. This is about a motion to strike the death penalty, right? You forgot about that one. We could use a timeline stream. Oh, God. Imagine putting a timeline together on this. Okay. Here we go. And there's more. Alleged aggravating circumstances of this crime highlight counsel's obligation to conduct a full, complete investigation, prepare a presentation that can withstand adversarial testing. Adversarial testing, so from the other side. So they have to know about what is adversarial. All right, so let's get to what you've all been wondering about, and that's this. So this thing about Dateline. Yeah. Chad Daybell went forward without a DP qualified attorney, and that's not enough to get it overturned, in your opinion. Yes, but it can take decades, though. We'll see. We'll see. We'll see. Hold on. So a continuance is also necessary to investigate and remedy the prejudice of highly inflammatory publicity released just weeks before the current trial date, including the recent Dateline NBC special and forthcoming book. This case has garnered substantial public interest, and the court previously issued a non-dissemination order restricting the release of certain information to the public in order to preserve the integrity of the proceedings and safeguard Mr. Kohberger's right to a fair trial. On May 9th, it was May 9th, there you go. You have the date. Just weeks before this capital trial is set to begin, that might be pushing it, it's more like months, is set to begin. Dateline NBC aired a 2-hour episode about this case titled The Terrible Night on King Road. It was pretty terrible. The program includes details of material, including video footage, cell phone records, and photographs of documents that are not publicly available through official channels. The show repeatedly emphasizes the non-public nature of this information, stating it was obtained from unnamed sources who are close to the investigation and that the materials were obtained exclusively by Dateline. Much of the investigative material presented by Dateline was taken out of context and will not be admissible at trial because it lacks reliability. The leaked materials appear carefully curated to promote a narrative of guilt. You don't say. That's fair enough, all unread. No defendant's rights are dependent on the type of representation they have, especially when it comes to the DP. Okay, so just because they're not DP qualified doesn't mean they automatically have, well, that's not an appellate issue. That makes sense. They chose. Yes, book. Who's writing the book? We're getting to that. We're getting to that. Friend of a friend of a friend of a Tinder date. Okay. As this court acknowledged in its May 15, 2025, documents and records hold order, the source of the leak is most likely someone currently or formerly associated with law enforcement or the prosecution team. If that's the case, it raises urgent and serious questions about the objectivity, judgment, and credibility of the individuals tasked with investigating and presenting the state's evidence, particularly those who may be called as witnesses. The identity of those involved, their motives, and any efforts to conceal their conduct go directly to the heart of witness credibility and the integrity of the state's case. I find this to be quite compelling. I find this to be more of a concern than anything else, really. So their motives and efforts to conceal their conduct go directly to the heart of witness credibility and the integrity of the state's case. Who are these people? And it's important to identify their motives and get to the heart, as I say, get to the heart of them, because their credibility as if they're witnesses, for example, or worse, if they are attorneys of record and they're actually involved in this, then that needs to be investigated and weeded out prior to trial, right? So if we've got law enforcement officers who are going to be getting up on the stand and they're going to be testifying for the state and they've been involved in this, they need to be found, they need to be investigated, and if they're part of it, they need to be struck from the witness list, right? I don't see any other way around it. Well, something needs to happen. Some sort of sanction needs to happen. Some remedy, right? If they're attorneys of record, guys, you tell me. I don't see how they can continue. It's pretty bad. It's pretty bad. Like, they're facing contempt of court, and that's from the judge's words. That's not me. That's the judge saying that. So if they're in contempt of court on this case and they're allowed to practice still on record as attorneys of record on this case, like, what credibility does the court have? So this is an incredibly strong argument, I believe. Like, this is far stronger than any of the discovery stuff we were talking about earlier, because of the fact that Old Line, I just saw your name come up. As Old Line was saying earlier, the judge has already ruled. He's already said, no, I'm not interested in talking to you about your concerns about discovery, right? He's ruled on that. Yeah, that they're not going to win a continuance based on the overwhelming discovery, right? That's just not going to happen. Now, Anne has gone and put in a bunch of other information regarding how the death penalty, or penalty phase of the trial is hanging in the balance because they're not prepared for that either, right? That's interesting because judge could go a different way and negotiate with the defense and take away the death penalty, because the death penalty is the thing that, aside from the discovery, is taking up more time, right? However, there's a bigger issue at stake too, and that is this investigation, right? So I just keep going here for a minute. The apparent leak is not only egregious by an egregious violation of the court's non-dissemination order, it enabled Dateline to gild rampant speculation with a veneer of credibility. When purportedly exclusive information surfaces through a media broadcast shortly before trial, particularly information attributed to unnamed sources with access to the investigation, it carries a heightened aura of credibility and secrecy that can deeply influence public perception. Unlike official disclosures, which are typically accompanied by context and procedural safeguards, leaks framed as exclusives are perceived as uncensored truths that the public was not meant to see. This insider framing enhances the material's persuasive power, suggesting that it is both authentic and revealing of the case's hidden realities. The episode includes things such as, this is bad, repeated speculative assertions regarding that the assailant's motives, including unfounded allegations of sexual motivation. Yeah, and guys, if you saw it, it was full of those, right? So nothing in the state's case that we know of has anything to do with sexual motives, right? Yet the Dateline episode made out that it was sexually motivated, or that he was sexually motivated, right? Photos of these women, right, cracking onto these girls. Oh no, a man who cracks onto girls, how terrible. But then this supposed search history of violent pornography, absolutely inflammatory stuff, right? I have huge doubts that something like that would be allowed into trial, right? I can't see how search history like that would be allowed in, especially considering that there's that we know of, no sexual nature to the crime. Dramatic reenactments and animations depicting the alleged crime created by the show's producers without basis in the evidentiary record. Emotional interviews. Poor Holly. With individuals connected to the alleged victims, accompanied by evocative music, photos, and videos designed to elicit strong emotional responses. Did that. The broadcast repeatedly bolstered its speculative claims throughout the use of so-called expert commentary. Oh my God. Well, I mean, really, Howard Bloom's he's got to be an expert by now. Including individuals identified as law enforcement professionals and academics. These commentators were permitted to make sweeping assertions about the defendant's alleged motives, psychological state, and personal history, none of which are grounded in evidence before the court, while the program repeatedly emphasized their training, research, and years of experience to lend undue credibility to their conjecture. This type of testimonial mimicry improperly mirrors expert witness testimony in a trial setting without the safeguard of cross-examination or evidentiary standards, effectively presenting the public with a one-sided, unvetted narrative that shapes juror perception before any admissible evidence has been presented. While the program occasionally inserts disclaimers such as, "We don't know what happened," these brief caveats do little to mitigate the cumulative effect of an extended narrative constructed through selective imagery, emotionally charged reenactive, and detailed speculative descriptions of the crime. When viewers are presented with a cohesive, visually reinforced sequence of events, especially when paired with commentary from individuals styled as experts, the overall presentation fosters a sense of authenticity and truthfulness that is difficult for viewers to disregard. An occasional passing verbal disclaimer functions more as a legal formality than a meaningful check on prejudicial perception, and most viewers will leave with the impression that they have seen a reliable reconstruction of events. And that is really like when you listen to people talk about the Dateline thing, they're like, "Oh, well, I found it very convincing." And Dateline, they're quite reliable, and they've been around for a long time, and they're very credentialed. They don't make things up. Now, getting on to the next bit. Who's Dr. B? I think he's guilty, but I'm keeping my mind open. Guilty, trying to be kind today. I roll my eyes. Oh, Mavka, everything on Dateline is 100% accurate. Okay, so this is news to me, this bit here. The Dateline special, which aired just weeks before the trial date, will not even be the last pre-trial media bombshell. Best-selling crime author James Patterson has written a book about the murders titled The Idaho 4, An American Tragedy. Sounds like the Gabby Petito one. Scheduled for release on July 14, 2025, just 16 days before jury selection is slated to begin. 16 freaking days, guys. Amazon, there's the link. Oh, yeah, we'll get to it in a minute. Last visited March 16, 2025. I wonder if it's still there. Oh, yeah, it's still there. I'll bring it up in a sec. I have to bring it up in a separate thing. So, yeah. So the blurb for the book describes Mr. Kohberger as a brilliant grad student, learner, apparent incel. Oh my God, incel. Not an incel. And explicitly tells the reader, now you are the jury. The evidence is in. Well, it's 16 days before jury selection, so I don't think the evidence is in. That doesn't really make sense. Okay. The publisher boasts of unmatched access to the investigation, including interviews with local law enforcement. Now, that's a problem. Local law enforcement is a problem. This suggests that the apparent Dateline leak was not the only violation of this court's non-dissemination order. The 6th and 14th Amendments guarantee the right to a fair trial by impartial jury. A continuance is necessary to fully investigate the leaks and to mitigate the prejudicial effects of such inflammatory pretrial publicity occurring so close to the current trial date. Okay, so that's a big deal, right? That's a pretty big deal. And they're smart to have gotten hold of that. They don't even know yet exactly what's in it, but if there's been another leak and it's going to come out just prior to trial, and they've got law enforcement interviews in there, they're smart to include that into this motion to continue. So, wow. Now, the Supreme Court has recognized that the passage of time can significantly reduce the taint. Taint has entered the chat, guys. The taint of media exposure, holding in Patton v. Yount that even in a case involving extensive coverage of a confession, the delay between media saturation and trial reduced its prejudicial impact. Huh. There you go. Taint. We have taint. Wow. Pre-trial publicity did not impair juror impartiality where, by the time of trial, the news value of the original disclosures was diminished, and the newspaper items were often relegated to the inner pages. Okay. So basically, they're trying to make a gap between where the prejudicial media has happened and the trial date. But that would mean that nothing more like this could happen in between times. And Bryan has to sit there in jail for God knows how long, hoping that nothing else like this goes on in the meantime. So that would mean shutting all these leaks up. So that would be the judge's responsibility. Meanwhile, the victims have to wait for justice, assuming that convicting Bryan Kohberger is justice. In sum, the 2-hour Dateline episode is uniquely prejudicial in both tone and content. It constructs a speculative narrative around motive and guilt, features emotionally manipulative production elements, and amplifies unsupported theories through self-styled expert commentary. Yeah, we know all that. Okay, so the court has already acknowledged that the Dateline special exposes a likely violation of the non-dissemination order, and Mr. Patterson's purported unmatched expert access to sources including local law enforcement suggests that multiple unauthorized disclosures have occurred. Depending on the results of the investigation into the leaks, a continuance may be inadequate. Once the sources of the leaks are identified and the full extent of misconduct revealed, the violations could warrant remedies more serious than delay. There you go. There's the hint. There's the hint. So she wants more than just a delay. She wants more. She probably wants the death penalty struck as well, or at least the death penalty struck. Now she's back onto the death penalty again. See how she's gone and segued immediately to the death penalty and gone, reversal is more likely than not, in any case, resulting in a death sentence. Statistically, almost 2/3 of death penalty cases are eventually overturned due to errors, often many years or even decades after the initial conviction. Wasn't that a nice segue? And there we have a footnote. In the only study of its kind, researchers conducted a comprehensive 23-year study, including 5,500 judicial decisions, reviewing outcomes of death sentences that have been fully reviewed through the appellate and post-conviction process and thus were final. Reversible error was found in 68% of the cases. So, she's basically trying to say that by not giving us a continuance to allow us to be completely ready for this, you're just going to take up court time and money, or state money, in appellate processes, and it's going to just get overruled anyway, right? So you might as well just strike the death penalty and save everybody a bunch of time and money. Because in most cases, 2 out of 3 cases, actually, that's what happens. So, do the right thing, Judge. This request is not made lightly. Defense counsel has worked around the clock actively, preparing for trial since appointment to this case. Filed all motions in a timely manner, complied with expert disclosure deadlines. There's a little dig. And had expected to proceed on schedule. However, it's become clear that without additional time, the defense cannot complete review of the necessary discovery, meaningfully respond to all the state's amended expert disclosure, another dig, and incorporate the information into an effective defense, and finish critical sentencing phase investigations. While prompt administration of justice is important to both the state and Mr. Kohberger, the constitutional guarantee of a fair trial outweighs modest delay. Wonder what she means by modest. And because the majority of cases ending in death penalty are later overturned for error, the public interest lies in ensuring a fair trial in the first instance. A continuance will ensure that Mr. Kohberger's fundamental constitutional rights are honoured and that any verdict rendered rests on a fair and complete presentation of the facts, not on forced haste. Oh, I'm the queen of taint. Old line. So my question is, if I'm Hitler, is how many documentaries and books are in the pipeline for exactly that reason? Because Hitler can't really say, I'm suspending the First Amendment while taint face. Yes. And tainted faint, fainted taint, faded taint, tainting faded taint. I don't know. That's actually what I was getting at earlier. Yeah. So what's he going to do? Is he going to continue it, do the investigation, get the special prosecutor in, do the investigation, do some sort of sanction? I don't know what, assuming they find the people who've done this. And then whilst there is the continuance, hope that nothing more happens, right? That there's no more leaks, yeah, and no more of these prejudicial documentaries and things, because come on, there will be, right? And yeah, like it does seem a bit not realistic, doesn't it? Right? But on the other hand, I feel like Anne has a point. Like if there are law enforcement officers and or attorneys who are responsible for this, they do need to be identified, especially if they're going to be witnesses or actually like working as attorneys on the case, right? Like if they're going to be part of the prosecution of the case, that's a big problem. So this is a hard one for him. It's a really hard one. So say the delay 3 months and then 2 more docs come out and another book, back to square one. Yeah. Yeah, exactly. And also, does that solve the problem of the mitigation, right? So I feel like there's 3 issues going on here. One of them is the discovery issue. Let's discount that, right? Because he's already ruled on that, right? He ruled on that in regard to death penalty, so there's no way he's going to make any allowance for that in regard to a continuance. Okay, so we can just go with that one. Yeah. The issue regarding being prepared for sentencing phase, that's got some legs. Maybe she hasn't really talked about that yet. In fact, I don't think she has brought that up at all. Yeah, she hasn't said she's not ready for sentencing phase until now. So that one could have legs. Yeah, she could possibly get a continuance based on just coming out and admitting, I'm not ready for sentencing phase, so I need a continuance. That's his right for us to be ready for a sentencing phase. Yeah. Tell me if I'm wrong on that one. Yeah. So he could be in a bind with that one. He might have to give her time for that. In regard to the issue with the non-dissemination order, I think he's going to view that as a separate issue. I think he's going to go and say, look, we are dealing with that. I have, I'm appointing a special prosecutor. I've put an order out there. and that, I mean, he'll probably be like, this book thing is a whole new one, but yeah, I don't tend to think he'll delay the trial because of it, because yeah, as you say, it could be a matter of how long's a piece of string, how many times are you going to delay it because of potential prejudicial media coming out there. So yeah, I tend to think this non-preparedness for the mitigation phase is the strongest argument. He can't put the entire of the press and all journalists in America under Idaho court's order. It's a terrible dilemma for everyone. And if any attorney was involved, they get to burn their bar card. Yes. I think that the attorneys have probably distanced themselves enough from this. There's probably 3 to 4 degrees of separation between the attorneys and the leak. Yeah, I don't think that they probably have that much to worry about. But there could be law enforcement that have things to worry about. There could be witnesses that are problematic, probably not key witnesses. I do tend to think this is going to go away. So when I say there's 3 to 4 degrees of separation, more than likely there's enough separation between key witnesses and any attorneys and the source of the leak for them to still have their entire case in chief covered, and they'll go to trial without having anyone taken away because of sanctions, remedies, contempt of court, anything like that. Obviously, it doesn't look good, but the court goes along and ticks the boxes of investigating this, and I think the state's probably covered their butt. Sure, they didn't expect this to happen, thought they'd get away with it, but even if it does get investigated in full, I think they'll be fine. Keep them separated. Yeah. It is an attorney, a paralegal, or most likely a cop. I think it's probably an investigator or someone like that. Someone expendable. Someone quite expendable. Someone who's not, they weren't intending to have testify. And someone nameless, you know. Anyway, so yeah, I do tend to think that the strongest argument for Anne for a continuance is the argument regarding being unprepared for the sentencing phase. And therefore, if like the easiest option in terms of getting the trial to happen on time would be to just strike the death penalty. But he really doesn't want to strike the death penalty. Really, really doesn't. But then on the other hand, she makes solid arguments regarding his constitutional right to counsel that is prepared for to fight for his mitigation. So, but he could just say, well, you had plenty of time. You've had plenty of time. So I tend to think this is all going to go ahead as planned. And yeah, the court will do as he did with his order regarding the motion to strike death penalty. What was it called? Just get the exact naming for it. His order on defendant's motion to strike death penalty and adopt other necessary procedures. And he will just pretty much argue as if he were arguing for the state, sweep for them and go, no, they've done nothing wrong and you've had plenty of time. And we're going to trial. That is my take on it. Very interesting, but I would love to know, I wish I were a fly on the wall for this. I wish I were a fly on the wall for this one. This hearing that happened on the 21st, the hearing with in-camera hearing, 10 a.m. at the 21st, and that one had the Gonsalves lawyer, Shannon Gray, there. Yeah, that would have been very interesting. Eric Bland comment, oh, I know, I saw. He's desperate for relevance. Dali sent me the clip of it, and it was like, and he couldn't even help like not going back to talking about Murdoch as well. He's like, I think she'll get a fair trial, just like Alex Murdoch got a fair trial. It's like, dude, really? Okay, this has been fun. So we'll talk more about Kohberger coming up. We'll see what happens. When I'm sure the state is going to respond to this. The state's going to respond and be like,
No, you're just not going to tell you it. No. No.
Let me guess. She bit him. He probably thinks she said that. That's how much of it he's been watching. Yeah. Yeah, I was like, thanks a lot for sending me Eric Bland as I woke up. I was like, AB. Yeah. All right. Thank you, guys. Have a great, what day is it for you? Thursday. It's Friday for me. I'm going to go hang out with my Seraph. Yay. And thank you for the donations for Seraph. Seraph Fund is going pretty good. If you want to donate to the Seraph Fund, it's pinned to the top of chat, everybody. So yeah, PayPal and Coffee Fund, much appreciated. And thank you for the donations, everyone who has contributed. I think I need to take him back for another checkup and get a couple more antibiotics and things for him. But yeah, he's doing really good. So thank you, everybody. And he says meow and hi.
Her name was Ella. She was an Aussie. She was a fake lawyer from the future. She got on YouTube and made some live streams. Her co-host is Donnie and she dances sometimes. The words are always so loud and because she's an 803. To be certain, excited utterance. Her cat is staring from